This is Timothy Perrone appearing on behalf of the defendants Brown, Doyle, and Leroy.
Okay, what's your name, sir?
James Ward.
Okay, you're the plaintiff in this matter?
I'm the plaintiff, yeah.
You're representing yourself, correct?
Yes, Your Honor.
Okay, today was scheduled for a motion, or two motions. One is just titled motion, the other one is a motion for leave to amend your complaint. There also was a motion for summary disposition. You received the motion for summary disposition, correct?
Yeah, I filed motions too, Your Honor.
I'm going to try to make my way through this because
Okay.
I'm not gonna miss anything. I have a motion, a notice of hearing for motion. It says a motion to amend complaint, and your motion in one sentence says there has been a crime committed 750.174. What kind of motion is that?
That's where, they had, I think that was the answer with the complaint.
You filed a motion to amend the complaint,
Right.
saying the motion only says there has been a crime committed. So when you make a motion, that means you're moving the court to do something. And I don't know what you are moving me to do in that
I'm
motion.
trying to get the video. See, that's the key thing.
Well, I want to know, what are you doing with it? When you put this motion to amend the complaint and say that there's been a crime committed, what are you expecting the court to move to do on your behalf?
I would expect to, the court to allow me the video of the money that was taken from me at the time when I left the jail. And then the issue I have is where now I looked in here because they refused to give me any names or anything when we first started.
Okay, so let me stop you because I'm going to tell you right now.
I'm trying to see where you're at.
Let me stop you because it's very confusing because you're trying to navigate a system that I'm clear that you don't know how to navigate because you've not probably versed yourself with the court rules.
Yeah, the whole thing reads like the plaintiff is trying to strong-arm discovery out of the defendants by slipping in an amended complaint and name-dropping a Michigan embezzlement statute that applies to custodial officials, which already makes zero logical sense in this context. But even if you pretend it did make sense, the case is sitting in small claims court, where the judge doesn't have the authority to convert, entertain, or rule on anything resembling a criminal allegation. There's simply no jurisdiction to amend a civil small claims filing into a criminal complaint, so the maneuver falls apart on every level, procedurally, substantively, and jurisdictionally.
Your lawsuit?
That's the basis of my
Okay, your
lawsuit.
motion is denied, it's improper. You can't file a motion to amend the complaint just to talk about the basis of your lawsuit. Don't tie up the court's time with that stuff.
Not the basis of my lawsuit.
Your motion, which is not properly filed, just says to amend the complaint. And the only thing you put in there is there was a crime committed. I asked you 3 times as to what you wanted to do with the complaint.
I'm trying to see where you're at, and I thought it was this one right here. It's a summons and complaint.
You need to know where you're at. You're the one who filed all these motions. And so this was filed on the 17th of May, but the motion is denied. Because you've not given me a basis upon which you feel your complaint needs to be amended. If the basis is because it's been moved from small claims to this court, that's not a motion to amend the complaint. Nonetheless, that's a motion for venue, not a motion to amend complaint. They changed venue.
They changed venue?
They moved it to...
They changed it, yeah.
Yeah, but you're asking to amend the complaint. So we're going to I'm denying that motion. I got to move to the next motion now. You filed a motion to set aside the defendant's motion for summary disposition and motion for discovery.
Yes.
What is the legal basis to which you believe you could set aside a motion for summary disposition?
Basis is because that is the main base of the complaint is because...
Do you know what a motion for summary disposition is?
Sort of.
The court doesn't have the authority to set aside their motion for summary disposition. You have filed a complaint against parties. The parties, if they believe that the complaint or the allegations lack certain merits can file a motion for summary disposition. You get to respond to that to show the court where, no, actually, to the contrary, this is an actual valid case, or I do have this information that would support the claim. Not
Right.
you didn't do that. You filed a motion for the court to set aside their motion for summary. The court can't grant that. So that has to be denied. You, however, I'm also asking for a motion for discovery. Is that what you're asking for?
Yeah, because that's the whole issue of why we're here in court, because they refuse to allow me to look at the video where they say there's only $5,000 when there's actually $8,000.
And why exactly would they let you review the video in the first place? They have no obligation to hand it over just because you ask. If you had even a basic grasp of how things actually work, you'd know that a FOIA request exists, and that's the proper route you'd have to take if you wanted access to that footage to use in your case.
You know what I mean?
I don't know what you mean.
Well, that would show exactly what was there. You know, how
You
much
want discovery
money was
so
there.
that you can try to prove your case.
Yes.
They filed a motion to get the case kicked, saying that there's essentially nothing really going on, or you're maybe suing the wrong parties. We're going to address I cannot set aside their motion for summary disposition. I'm going to let them argue their motion. You've not responded to their motion. I don't see that you responded to the motion.
I have responded to the motion.
You filed a response to their motion?
Yes.
I have. I was waiting
Okay.
for the video so I can do a complete summary disposition, because it'll show the exact events.
Okay, let's see what this is. Maybe this is it. They should probably label stuff a little better and not just put response. Plaintiff answers? No. I'm assuming, is that supposed to be the response? What does your response look like? I have something here that's been filed. It just says plaintiff's answers. Was that supposed to be your response to the summary disposition?
That's it. Certificate of compliance, plaintiff's answers.
That's your response to their motion?
Defendant's motion for the summary disposition. Yes.
Okay, thank you. Mr. Perone, it's your motion. You can make your argument on the record.
Well, thank you, Your Honor. We're here today on the plaintiff's two motions. My motion for summary disposition is noticed for July 8th. But it is correct that the plaintiff did file what he calls answers to our motion for summary disposition, and that would have been a valid reason for this court to deny his motion to set aside motion for summary disposition. Of course, there is no lawful authority for that. Otherwise, he has this other aspect of his pending motion for discovery, and we filed our response on that it is improper and premature. He's never made a discovery request, and nothing was refused.
Not sure.
He hasn't identified what he wants or why he wants it, and there's generally no discovery in district court. And as we've mentioned in our motion for summary disposition, he named 3 people that have nothing to do with his money. Okay, and they weren't the ones who confiscated the money when he went into custody. They weren't the ones who counted it. They weren't the ones who were responsible for accounting for the money. They were completely unrelated to the incident of him being taken into custody and having his money put into storage. And that's the main basis for our motion for summary disposition. But we also established by multiple affidavits in our motion that the people who did handle the money counted it correctly, and that he signed a receipt indicating that the amount was correct.
There's a difference between having receipts and having the receipt. The one you actually signed that spells out exactly how much money was taken from you during intake. That document is the proof that matters, not vague claims or secondhand paperwork.
There was an extensive investigation conducted by Lieutenant Brown, who's listed as a defendant here. Her role was to conduct an investigation, and she concluded that the amount of money that was seized was accurate and fully accounted for. There was no missing money. He says he has more than what was on his person when he was taken into custody, but he didn't. And we've established that separately in our motion for summary disposition, but really he's naming 3 people who have nothing to do with it. And that's primarily the basis for our motion for summary, which is scheduled for July 8th. But he did answer, and he didn't produce any affidavits. He didn't produce any evidence. He just called it answer, and for the most part, he neither admitted nor denied. And so it ultimately comes down to he really isn't even putting up a defense to our motion. He just doesn't want it to be granted. That's all. Thank you.
Thank you. Sir, do you want to?
That's not a fact, what he's saying, Your Honor. The truth of the matter is, they've been holding the video from day one.
Did you,
I've been asking for the
you
video.
FOIA the
from day
video
one,
from them?
What?
How did you request the video?
Ocean Discovery. I talked to him. I talked to the other lawyer, Bonnie, and asked her to make a meeting. She denied the meeting.
I don't need any. I don't need pictures.
She denied the meeting. She didn't meet up with me or have a discussion. So I come up here and
You
filed
requested a
motion
meeting
to
with
compel.
who?
Huh?
You requested
Bonnie.
who?
Bonnie Toski.
Okay.
That's-
What does that have to do with you making a formal request for discovery or for information? So typically, if you want something from the government, whether it's a police report or anything else that is supposed to be accessible under the Freedom of Information Act, you make a FOIA request. Have you made a FOIA request?
I did all that.
When?
They denied me from day one, from the day it started.
When did you make the FOIA request?
The day that it started, that this happened, it was on the 25th.
25th of what?
I think it was the 28th or 29th. I made it.
Of what?
Uh, 24?
Of what? We're in June. When did this happen? When did you FOIA?
The day that this happened.
I don't know when that. You're talking to me like I was there. You're supposed to tell me the date. If you don't know the date, you don't.
Damn, Judge Simmons is really not playing around with this adult. I've covered her before on my channel, so this isn't new behavior, but every time she's on the bench, it's the same energy. Total control, zero tolerance for nonsense. She's basically the female version of Judge Oakley, composed, authoritative, and completely unfazed by theatrics or excuses. From the moment she speaks, the room shifts. You can tell she knows the law inside and out, expects professionalism, and isn't afraid to shut things down the second they cross the line. This is exactly what it looks like when a judge fully owns their courtroom and makes it clear that respect isn't optional.
This has been going on for several months.
You're going to tell me you're the one suing. You better know your facts. What date did the incident allegedly occur?
Back on the 25th.
Of what?
The first.
The first
January.
what? January 25th?
Yes.
Okay, of this year?
Yes.
And when did you make a FOIA request?
The 28th.
Of January?
Yes.
Your allegations for your complaint is that you were taken into custody in a criminal matter, is that correct?
Yes.
And that you at the time had some cash on you?
I had 8.
I just answered my question.
Yes.
And you alleged that the amount that you had was $8,010.39 is what you're stating?
Yes.
But that you only received back $5,910
Yes.
and 37 cents. And but you're claiming damages of $7,000.
Well, yeah, because it's costing me more money than $7,000. That's because the initial was at small claims. So if $7,000 is the most that you can sue for.
I get that, but why are you claiming damages of $7,000? You don't get to just claim amount just because
Because
that's
of the
most.
damages that was done to me, what I had to go through to get it, the embarrassment.
The embarrassment?
The embarrassment and everything, yes.
What embarrassment?
where I have to come to the court and have to deal with the court system because they stole money from me and they're supposed to be a law enforcement.
You can't allege that you lost
I didn't
2,000.
lose nothing.
You
The police, the jail.
you cut me off again, you're gonna lose this case immediately, okay? You can't allege that you suffered a loss. If you're suing us, making a civil lawsuit, you need to know the terminology. You can't allege in a lawsuit that you suffered a loss of about $2,001, but you're suing for $7,000.
Because of the damages.
You have to tell me what the damages are. You have to allege that in your lawsuit. An embarrassment that you don't get. You don't get excuse me,
Mr. Ward. It is.
Don't, please, I'm gonna correct it.
I don't think I'd ever want to find myself in front of a judge who calmly tells the bailiff to stand down because she'll handle the correction herself. That's the kind of confidence that lets you know enforcement isn't coming from muscle. It's coming straight from the bench. When a judge reaches that point, you're not dealing with warnings or theatrics anymore, just authority delivered in the most controlled way possible.
You don't cut me off. You understand that?
I wasn't trying.
You have to show me some tangible damage. You're not getting any pain and suffering. You're not getting any money for embarrassment. How did it cost you $7,000 to try to get this money back that you allege is missing?
The time I have to spend at the library, the time I have to drive from Mason to here, it cost me in gas.
It cost you $5,000 in gas to get
I'm
here
sure it cost
from Mason.
me pretty close to that.
$5,000
In gas
from Mason.
and time. And
to go 10 miles away. It cost you $5,000 in gas.
time.
Okay.
And time at the library.
Okay, sounds good. I recognize that your motion was scheduled for a hearing on the 8th, but you're both here today. The court's already read the plaintiff's motion. And why are you suing the defendant's motion? And you've already responded to the defendant's motion. Why are you naming these people? Why do you feel like they're if in fact you were lost some money, why were they the people that were responsible?
Because they're the ones that was involved in part of this, and they're hiding the evidence of the money being taken.
How were they involved? And how are they?
They're involved by when they involved themselves, saying that they viewed the videotape and all this extra that's not the factual basis.
Were they present when you were arrested?
No, they're the people I contacted.
I didn't ask you to answer my questions. They weren't present when you were arrested. Did they take money out of your pockets, or did they confiscate the money when you were arrested?
I can't tell you exactly who took the money because they.
Did you see them take any money from you?
I didn't see anybody take the money.
Okay.
Except for the two who took it out of my pocket.
Who were the two who took it out of your pocket?
Doyle.
You're saying Sergeant Doyle took money out of your pocket?
Doyle and no, Matthew Powell it is, sorry.
Matthew Powell took money out of your pocket when you were arrested?
Yeah.
Not Chad Doyle?
No.
Not Melissa Brown?
Melissa Brown and Chad Doyle is the ones that refused to show me the video where it shows that there was not 8,000. They're saying it's 5,000.
So let me get this straight. You're suing 3 people who weren't even the ones who supposedly took your money in the first place. Yet you're citing a criminal statute that would only apply to the 2 jailers who allegedly handled your intake funds. That code wouldn't reach the 3 individuals you're actually suing at all, unless the theory is that refusing to entertain your delusions somehow counts as embezzlement, which it obviously doesn't. The whole argument collapses the moment you line up who did what against the law you're trying to invoke.
That's not true. If they show the video,
did you sign a receipt?
There was never no.
You never signed a receipt.
There was never no amount of money that was on that receipt, ma'am.
Mr. Perone, what did you
asked for a receipt.
Mr. Perone, did you attach a copy of this receipt?
Yes, I did, Your Honor. It's on our summary disposition motion. It's one of the exhibits is the receipt. It's just a little slip of paper that has the amount and some initials on it, but that's essentially it. And the video, I It mentioned the video, but it really doesn't provide detail of showing the amount of money that was counted there. It just shows people's backs at a table counting money. It really
I have a
wouldn't
copy.
provide any level of detail.
Inmate name and number, James Ward. That's the receipt you're trying to show me, sir?
Yeah,
Okay,
inmate name and number.
okay. And you see the amount that was tendered on
It's
there?
got 3 amounts.
Do you see the amount on there?
It's got 3 amounts, yes.
I see
It's got
$5,910.36,
4.
and then there in quotation says 37 cents. Is that what you're talking about?
One says 36, one says 37. This one here says 5,594. This one says 5,528.
I don't know that that's an amount of money. I don't know what those numbers are.
Well, that's what it looks like to me. I'm not trying to be no rocket scientist, but that's what it looks like to me.
Okay.
Well, humanity can collectively breathe easier knowing you're nowhere near a launch pad or trusted with anything that actually matters to life on this planet. Some responsibilities are clearly better left in more capable hands.
But James Virgil Ward, it has an inmate number on there and a receipt number, correct?
Yeah.
Okay, so then you were provided a receipt then, correct?
No. This was not provided to me. I asked for a receipt when I was there. If you get the video, it shows right there too that I asked for a receipt.
Okay.
You can go look at this.
I'm not going to go look at anything. I'm going to make my ruling. Just based on your statements today, the argument of the defense is that you named the wrong parties.
No.
Excuse me?
No.
Your case is dismissed because you did name the wrong parties. You stated it here on the record.
That's fine.
These people were not even.
I'll-
Hey, next is contempt. You named the wrong parties. The individuals you named were not even present during the incident alleged. You are trying to sue the people that you made a request for video from or a request for them to investigate because you didn't like their findings. But that's not a proper way to address that. You need to sue the proper or appropriate parties that you allege wrongfully confiscated your money if that's how you want to pursue. This case is dismissed.
So, case dismissed, and everyone gets to go home, right? Wrong. And that's exactly why I said at the beginning that by the end of this, there'd be evidence suggesting he might be a sovereign citizen. Now that you've seen how it played out, I'll leave it to you to decide.
You're all set, sir.
Can I get
Thank
your
you.
bonding number?
My who?
Your bonding number?
I don't have a bonding number.
Okay, well,
I'm a judge.
that's fine.
Yeah, your recourse is to file an appeal if you don't like my ruling.
No, I'm filing
That's-
1993.
Oh, you can do that as well if that's what you would like.
That's what I'm doing.
Have a good day.
Demanding to see the judge's bond, threatening to sue the court, and casually dropping a reference to suing under in 1993, which he almost certainly meant as 42 U.S.C. S. 1983, the GOTA statute sovereign citizens love to wave around when they think a judge or any state actor has violated their rights. That playbook is so familiar it's practically scripted at this point. So is he a sovereign citizen? For me, he checks every single box, but I'll let you be the judge. Drop your thoughts in the comments and tell me what you think.